To this argument I am respectfully unable to accede. I do not think that the Defence of the Realm Acts can be submitted to such a violent and strained construction. Page 285. The words, it is said, are perfectly general. The King in Council is vested with powers to judge of what is for the public safety and the defence of the realm, and to act accordingly. All the rest of those statutes, as to trial, intimation, notification of rights, every provision for the legal disposal of the question affecting liberty, all this is on one side, the side of offence against a regulation. On the other side stands the supereminent power of the government of the day. In the exercise of that power, the plainest teachings of history and dictates of justice demand that, on the one hand, government power, and on the other, individual rights, these two shall face each other as party and party. But it is not so. So it is said, here the government as a party shall act at its own hand, the subject as a party shall submit and shall not be heard. The government is at once to be party, judge, and executioner. When, so is the logic of the argument, Parliament took elaborate pains to make a legal course and legal remedy plain to the subject as to all the regulations which were stated in detail, there was one thing which Parliament did not disclose, but left courts of law to imply, namely, that Parliament, all the time and intentionally, left another deadly weapon in the hands of the government of the day, under which the remainder of those very acts, not to speak of the entire body of the laws of these islands protective of liberty, would be avoided. As occasion served the government of the day, despotic force could be wielded, and that whole fabric of protection be gone. My lords, I do not believe Parliament intended anything of the kind. End quote. Page 307, Lord Wrenbury, quote, there is room for difference of opinion whether what I may call legislation by devolution is expedient, whether a statute ought not to be self-contained, whether it is desirable that a statute should provide that regulations made by a defined authority or in a defined manner shall themselves have the effect of a statute. But I think it clear that this statute has conferred upon His Majesty in Council power to issue regulations which, when issued, will take effect as if they were contained in the statute. No doubt every statutory authority must be exercised honestly. There is, I conceive, no other limit upon the acts that the regulations may authorise to achieve the defined object. End quote. Institute of Patent Agents and Lockwood, L.R. 1894, Appeal Cases 347. By Section 101 of the Patents, Designs and Trademarks Act 1883, the Board of Trade were given power to make such general rules as they thought expedient, subject to the provisions of the Act, for regulating the practice of registration under the Act, subsection 3, provided that rules made in pursuance of the section should, subject as thereafter mentioned, be of the same effect as if they were contained in the Act, and should be judicially noticed, and subsection 4, that any rules made should be laid before both Houses of Parliament and should be advertised. Subsection 5 provided that if either House, within 40 days after any rules had been so laid before the House, resolved that such rules or any of them ought to be annulled, the same should, after the date of such resolution, be of no effect. By Section 1, subsection 2 of the Patents, Designs and Trademarks Act 1888, a further power was given to the Board of Trade to make general rules for the purposes of that section, and it was declared that the provisions of Section 101 of the Act of 1883 should apply to all rules so made as if they were made in pursuance of the said Section 101. The Board of Trade having made rules in pursuance of the above-mentioned powers, which were laid before Parliament and not objected to within the 40 days, the Lord Chancellor, Lord Herschel, Lord Watson, and Lord Russell of Killowen expressed the opinion, Lord Morris on this point dissenting, that it was not competent for the courts to question the validity of the rules. Page 358, the Lord Chancellor, Lord Herschel. So far I have dealt with the question whether the rules are, page 359, intra vires, but there is no doubt another very important question which has been argued before your lordships, namely, whether this question can be canvassed in the courts, when once the rules have been made by the Board of Trade and laid as provided on the tables of both Houses of Parliament. It is said that it is only rules properly made under subsection 2 which can become part of the Act and be treated as such. My lords, the words of subsection 2 are, the Board of Trade shall as soon as may be after the passing of this Act, and may from time to time make such general rules as are in the opinion of the Board required for giving effect to this section, and the provisions of Section 101 of the Principal Act shall apply to all rules so made as if they were made in pursuance of that section. Therefore, any rule which in the opinion of the Board of Trade is required to be made in order to give effect to the section is a rule made pursuant to the provisions of subsection 2, and any rule made pursuant to the provisions of subsection 2 is to be dealt with as if made in pursuance of Section 101 of the Principal Act. Now, let us see what is to be the effect as regards rules made in pursuance of Section 101 of the Act of 1883. First of all, the Board of Trade may from time to time make such general rules and do such things as they think expedient, and their general rules may be made under this section at any time after the passing of this Act, but not so as to take effect before the commencement of this Act, and shall, subject as hereinafter mentioned, be of the same effect as if they were contained in this Act, and shall be judicially noticed. The subject, as hereinafter mentioned, is this, that they are to be laid before Parliament, and remain before Parliament for consideration for 40 days, and during those 40 days they may be annulled by a resolution of either House. If not so annulled, or until so annulled, what is the effect? They are to be of the same effect as if they were contained in this Act. My Lords, I have asked in vain for an explanation of the meaning of those words, or any suggestion as to the effect to be given to them if, notwithstanding that provision, the rules are open to review and consideration by the courts. The effect of an enactment is that it binds all subjects who are affected by it. They are bound to conform themselves to the provisions of the law so made. The effect of a statutory rule, if validly made, is precisely the same, that every person must conform himself to its provisions, and if in each case a penalty be imposed, any person who does not comply with the provisions, whether of the enactment or the rule, becomes equally subject to the penalty. But there is the difference between a rule and an enactment, that whereas, apart from such provision as we are considering, you may canvass a rule and determine whether or not it was within the power of those who made it, you cannot canvass in that way the provisions of an Act of Parliament. Therefore, there is that difference between the rule and the statute. There is no difference if the rule is one within the statutory authority, but that very substantial difference if it is open to consideration whether it be so or not. I own I feel very great difficulty in giving to this provision that they shall be of the same effect as if they were contained in this Act, any other meaning than this, that you shall for all purposes of construction or obligation or otherwise treat them exactly as if they were in the Act. No doubt there might be some conflict between a rule and a provision of the Act. Well, there is a conflict sometimes between two sections in the same Act. You have to try and reconcile them as best you may. If you cannot, you have to determine which is the leading provision and which the subordinate provision, and which must give way to the other. That would be so with regard to the enactment, and with regard to rules which are to be treated as if within the enactment. In that case, probably the enactment itself would be treated as the governing consideration, and the rule as subordinate to it. Those are points that I need not dwell upon on the present occasion. Although it is not necessary for the determination of this case to express an opinion upon it, yet, as the matter has been so much discussed, I think it only right to express the opinion which I entertain, that the words to which I have referred are really meaningless unless they have the effect which I have described, and they seem to me to be the apt and appropriate words for bringing about the effect, page 361, which I have described. They are words, I believe, to be found in legislation only in comparatively recent years, and it is difficult to understand why they have been inserted unless with the object I have indicated. End quote. Page 364, Lord Watson, quote, Now, it appears to me that the whole scheme was left to the discretion of the Board of Trade, and it is impossible for me to say that, looking at those regulations, the Board of Trade have in any measure exceeded that discretion. It was by their opinion, not by any judicial opinion, that the matter was to be determined. The legislature retained so far a check that it required that the regulations which they framed should be laid on the table of both houses, and of course these regulations could have been annulled by an unfavourable resolution upon a motion made in either house, but what is to be the effect if no such motion be made or carried, or if a motion hostile to the scheme be made in both houses and rejected by both? The statute makes no difference between these cases. The views expressed by the learned judges in the court below, so far as I understand them, would in the latter case make it competent for the court to inquire at its own hand whether or not the board had kept within the statute, although the legislature had declined to interfere. But I think that all doubt upon that subject is entirely removed by the terms of Section 101 of the Act of 1883, which for all practical purposes is incorporated with Section 1 of the later Act. Any rules made in pursuance, page 365, of this section shall be of the same effect as if they were contained in this Act, and shall be judicially noticed. My Lords, in regard to these words which I have just read, I do not think I can express my opinion more clearly than by saying that I think they mean exactly what they say. Such rules are to be as effectual as if they were part of the statute itself. End quote. Lord Morris, quote, I cannot go to the further proposition which, as I understand, the noble and learned Lord on the woolsack has laid down, that it is not competent for the courts of justice to consider whether these general rules are intra vires or ultra vires. I am of opinion that it is not alone competent for the courts of justice to consider, but that it is their duty to consider whether the rules are ultra vires, that there is no power delegated by the legislature to the Board of Trade to make any general rules which, when made, are to be considered intra vires, provided they are laid before both Houses of Parliament, and provided that nobody has taken the trouble either to read them or to make any motion upon the subject. Now, I admit that the words are very strong. The general rules are to have the same effect as if they were embodied in the Act. I accede to that. But what general rules? General rules which are made for giving effect to that section? Not all general rules. There is no such power, in my opinion, given to the Board of Trade. What are the general rules which are to have the same effect as if they were contained in the Act? The general rules made under the section, general rules such as the legislature has, under Section 101, delegated to the Board of Trade the authority of making. But if a court of justice, before whom all these questions must ultimately come, considers that certain rules are rules which do not come within this section, in my opinion they would be ultra vires, and it would be the duty of the court not to regard them as operative. As regards the question of their receiving any further sanction from the fact of their being laid before both Houses of Parliament, that is a matter of precaution. They do not receive any imprimatur from having been laid before both Houses of Parliament. It is only that an opportunity is given to somebody or other, if he chooses to take advantage of it, of moving, that they be annulled. End quote. Page 367, Lord Russell of Killowen. Quote, I think that if the rules are to be read as part of the Act, as I think they ought to be, it is not, in this case, competent to judicial tribunals to reject them. Such effect must be given to them by judicial construction, as can properly be given to them, taking them in conjunction with the general provisions of the Act or Acts of Parliament in connection with which they have been formulated. End quote. Chester and Bateson, L.R. 1920, 1 King's Bench 829. Reg 2a, subsection 2 of the Defence of the Realm Regulations was as follows. If, as respects any area in which the work of manufacturing, producing, repairing, storing or transporting war material is being carried on, the Minister of Munitions is of opinion that the ejectment from their dwellings of workmen employed in that work is calculated to impede, delay or restrict that work, he may by order declare the area to be a special area for the purpose of this regulation. Whilst the order remains in force, no person shall, without the consent of the Minister of Munitions, take, or cause to be taken, any proceedings for the purpose of obtaining an order or decree for the recovery of possession of, or for the ejectment of a tenant of, any dwelling house or other premises situate in the special area, being a house or premises in which any workman so employed is living, so long as the tenant continues duly to pay the rent and to observe the other conditions of the tenancy, other than any condition for the delivery up of possession. If any person acts in contravention of this regulation, he shall be guilty of a summary offence against these regulations. Held that the making of this regulation was not a valid exercise of the power of His Majesty in Council to issue regulations for securing the public safety and the defence of the realm given by the Defence of the Realm Consolidation Act 1914, 5 George V c. 8, Section 1, and was ultra vires. Page 832, Judge Darling. This case came before this court on a case stated by the justices sitting for the Petty Sessional Division of Lonsdale North in Lancashire, and after the argument for the appellant, the respondent not being represented, we reserve judgment. This case raises the question where the Reg 2a subsection 2 goes beyond the authority by the statute 5 George V c. 8, confided to His Majesty in Council, to be exercised during the continuance of the present war for the defence of the realm. The authority to make this regulation is to be found, if anywhere, in 5 George V c. 8, section 1, subsection 1, par e, in the words, otherwise to prevent assistance being given to the enemy or the successful prosecution of the war being endangered. It is objected that the regulation is bad because it forbids any person, without the consent of the Minister of Munitions, to take or cause to be taken any proceedings to recover possession of his own house or to eject a tenant from it where the tenant is employed in certain work connected with war material. Mr. Langdon has contended that this regulation violates Magna Carta, where the King declares, to no one will we sell, to no one will we refuse or delay right or justice. I could not hold the regulation to be bad on that ground, were there sufficient authority given by a statute of the realm to those by whom the regulation was made. Magna Carta has not remained untouched, and like every other law of England, it is not condemned to that immunity from development or improvement which was attributed to the laws of the Medes and Persians. I found my judgment rather on the passage in R v. Halliday, 1917, AC 268, where Lord Finlay says that Parliament may entrust great powers to His Majesty in Council, feeling certain that such powers will be reasonably exercised, and further, on these words of Lord Atkinson in the same case, it by no means follows, however, that if on the face of a regulation it enjoined or required something to be done which could not in any reasonable way aid in securing the public safety and the defence of the realm, it would not be ultra vires and void. It is not necessary to decide this precise point on the present occasion, but I desire to hold myself free to deal with it when it arises. Here I think it does at last arise, and I ask myself whether it is a necessary or even reasonable way to aid in securing the public safety and the defence of the realm to give power to a minister to forbid any person to institute any proceedings to recover possession of a house so long as a war worker is living in it. The main question to be decided is whether the occupant is a workman so employed, and the regulation might have been so framed as to make this a good answer to the application for possession, still leaving that question to be decided by a court of law. But the regulation as framed forbids the owner of the property access to all legal tribunals in regard to this matter. This might, of course, legally be done by Act of Parliament, but I think this extreme disability can be inflicted only by direct enactment of the legislature itself, and that so grave an invasion of the rights of all subjects was not intended by the legislature to be accomplished by a departmental order such as this one of the Minister of Munitions.